This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. All right, it was reported this week that in Ohio, a lawyer was disbarred after sleeping with his indigent client. An indigent client is someone who can't pay, but actually that's not what they were disbarred for. They were suspended for that and then disbarred for continuing to practice law after being suspended. Let's take a look at what's going on here. Jessica Mustin was killed on June 23, 2018, when her vehicle collided with a vehicle traveling in the wrong direction on a highway in Cleveland. At the time of her death, Jessica had a 4-year-old son and was in a relationship with Anthony Hodge. Hodge referred Jessica's mother, Juanita Mustin, to Sarver to pursue a wrongful death claim. On June 30th, 2018, Juanita Mustin signed a contingent fee agreement in which she agreed to pay Sarver 33% of any settlement obtained without filing a lawsuit. That's normal. The 33% is quite a normal contingency fee arrangement. Sometimes it goes as high as 40%. I think we saw Leibowitz's copyright contingency agreement was 50%. I'm not sure where at some point this becomes too high, but 33% is quite normal. Sarver later agreed to help Mustin pursue a claim with the Ohio Victims of Crime Compensation Program. For the first 5.5 months of representation, he communicated with Mustin only by telephone or through Hodge. Sarver notified the other driver's insurer, Allstate Insurance Company, that he was representing Jessica's estate, and on August 21, 2018, Allstate offered to settle the estate's claim for its policy limit of $50,000. So I guess that's the maximum the insurance carrier would be able to give. Sarver informed Mustin of the offer and told her that all proceeds of the settlement, less his attorney's fees and costs, would be held in trust for Jessica's minor son. He advised Mustin that he would need to complete some paperwork for the probate court before any of the proceeds could be distributed. On September 6, 2018, Sarver accepted Allstate's settlement offer on Mustin's behalf. He also prepared and obtained Mustin's signature on various probate documents, including an application for authority to administer the estate and an application to approve the settlement and distribution of wrongful death and survival claims. He took those documents to the Cuyahoga County Probate Court on October 15, 2018, but only filed the application for authority to administer the estate. Throughout Relator's investigation of this disciplinary proceeding, Sarver has claimed that he did not file the other documents because a magistrate either told him or led him to believe that he could streamline the probate court proceedings by dispersing some of the settlement proceeds to family members at the direction of the fiduciary to reduce the distribution to Jessica's son to less than $25,000. The magistrate did not recall having spoken with Sarver, and she submitted an affidavit in this disciplinary proceeding that contradicted Sarver's claim. She averred that she had never advised any attorney or layperson to distribute the proceeds of a personal injury or wrongful death case, either without the probate court's approval or pursuant to the administrator's directives, or so as to attempt to reduce the funds to a minor child to less than $25,000. I mean, I'm not a probate attorney, but it sounds like they were trying to get the child to have less money? That's weird. Sarver testified that he did not believe that the magistrate's affidavit was false or incorrect. Therefore, the board determined that Sarver's statements about the magistrate's advice were false, and that the real reason he elected not to file the other probate documents was that they could not be filed until Mustin was appointed as the fiduciary. On November 26, 2018, Sarver posted a $10,000 bond on Mustin's behalf. That same day, the court appointed Mustin as fiduciary of Jessica's estate and issued her letters of authority. On November 28, 2018, this court suspended Sarver from the practice of law for 2 years with 18 months conditionally stayed. In December 2018, Sarver filed in this court an affidavit of compliance stating that he had complied with the suspension order and that he had notified his clients and the courts in which he had pending cases of his suspension. He has now stipulated that, contrary to his affidavit of compliance, he had not notified Mustin, the probate court, Allstate, or the OVCCP of his suspension. What's the OVCCP? The Ohio Victims of Crime Compensation Program. Despite his suspension, Sarver continued to represent Mustin. Just 2 days after he was suspended, he wrote a letter to the OVCCP on his law office letterhead, which identified him as an attorney. He closed the letter, "We look forward to working with you on this claim." And here's where I just lose it. Like, any compassion I had for Sarver, why, after you get suspended for only 6 months, so 18 months conditionally stayed, in other words, you comply and you're only suspended for 6 months, why would you continue practicing? At this point, do everything you're supposed to, because they're going to give you your law license back. They're going to let you practice again. Why would you then double down? That same day, he signed Mustin's name to a settlement release, falsely notarized that signature, and sent the document to Allstate. On December 10th, 2018, Sarver received a settlement check, signed Mustin's name to it, and deposited it to his client trust account. Okay, I'm going to say something weird here. I would never violate a client's trust, but he allegedly did this for less than $50,000, for basically a third of $50,000. How? Why would you throw away your entire career? Like, okay, if there was some life-changing amount of money, I could at least understand the conflict. Again, I don't condone it, but I would at least better understand if it was millions of dollars he was trying to get, rather than $13,000, $17,000. What is a third of $50,000? 50,000 divided by 3 would be $16,666.67. That's an unbelievably small amount of money to throw your entire career away for. Again, I don't condone it, but in this case, I really don't understand either. After depositing the check into his trust account, Sarver began to distribute the settlement proceeds without the probate court's approval. He immediately began paying personal financial obligations directly from his client trust account, also a huge no-no, with what he had calculated to be his earned fee. You're supposed to take, if there's money that needs to be separated out of a settlement like that, you more or less immediately take that money out of the trust account and put it in your personal account. Then you pay for things. You never use a law firm check to pay for personal expenses. Never, ever, ever, ever. At his disciplinary hearing, Sarver testified that Mustin had verbally authorized him to sign the settlement release and check on her behalf, but the board found that he had attempted to duplicate Mustin's signature, and that effort would have been unnecessary if he had permission to sign the document and check on her behalf. And Mustin's testimony was clear. She never gave Sarver permission to sign her name on the document or the check. So now he's accused of also signing the client's name without her authorization. No. In mid-December 2018, Sarver met Mustin for the first time at her home, and contrary to the application to approve the settlement and distribution of the wrongful death proceeds that she had previously signed, he gave her a check for $4,734. He suggested that they make a $2,500 distribution to Hodge, and he later issued a $2,000 check to Earth Temple, a 501c3 corporation registered to Hodge. Although Sarver claimed that he and Mustin had mutually agreed to make these distributions, Mustin testified that she never asked Sarver for the money because she knew that the settlement proceeds would go to her grandson. She said that Sarver told her that her check was an early Christmas present and that he was giving it to her for tax reasons. Mustin also testified that she went along with Sarver's suggestion that because Hodge was dating Jessica at the time of her death, he should get a portion of the settlement proceeds. What? On February 5th, 2019, an OVCCP representative called Mustin to discuss her case and informed her that he could no longer work with Sarver because Sarver's law license had been suspended. This was the first time that Mustin heard of Sarver's suspension, more than 2 months after his suspension, and more than 1 month after he avowed to this court that he had indeed informed Mustin of his suspension. When she called Sarver to ask about his suspension, he admitted that his license had been suspended, but further stated that it would be reinstated in a couple of months. He did not advise her to consult with other counsel, nor did he return her file to her. No, if you get suspended, you must stop. You can't do you can't coast through the suspension with your existing clients and then hope nobody notices and you come out the other side reinstated like nothing ever happened. That is not how that works. You have to actually suffer the punishment of suspension. The parties stipulated and the board found that Sarver's conduct violated Rule of Professional Conduct 116D, requiring a lawyer to promptly deliver client papers and property as part of the termination of representation. 5.5a, prohibiting a lawyer from practicing law in a jurisdiction in violation of the regulation of the legal profession of that jurisdiction. 8.1a, prohibiting a lawyer from knowingly making a false statement of material fact in connection with a disciplinary matter. 8.4c, prohibiting a lawyer from engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. And 8.4d, prohibiting a lawyer from engaging in conduct that is prejudicial to the administration of justice. Sarver also stipulated that he violated Professional Conduct Rule 3.4c, prohibiting a lawyer from knowingly disobeying an obligation under the rules of court by failing to notify Mustin of his suspension and by paying himself attorney's fees without first obtaining the probate court's approval, in violation of the local rules of the Cuyahoga County Probate Court. However, he contested an alleged violation of Rule of Professional Conduct 1.4a, requiring a lawyer to inform a client of any decision or circumstance with respect to which the client's informed consent is required, arguing that the charge was duplicative of the stipulated 3.4c violation and that both allegations arose from his failure to inform Mustin of his November 2018 suspension. I'm pretty sure it doesn't work that way. Unlike when you're making a claim against a party in like a civil lawsuit or something where you don't get additional damages because you can stack claims or something like that. Rules of professional conduct violations do stack, and I don't think that you can get out of them that way. The board found that Sarver had a duty to comply with the court's suspension order and a separate duty to keep Mustin reasonably informed. Specifically, the board determined that the decision on how to proceed in the face of Sarver's suspension required Mustin's informed consent, and that the choice should have been between obtaining new counsel and delaying the insurance settlement and administration of the probate estate until Sarver's license was reinstated. Consequently, the board found that Sarver violated both 3.4c and 1.4a1. Okay, so that's weird. The board determined that the choice should have been between obtaining new counsel or simply delaying the proceeding. So the client could have opted to keep the attorney, but delay it by 6 months so he can comply with the suspension and then get reinstated. I didn't think that was a choice, but okay. In support of his first objection, Sarver asserts that his representation of Mustin terminated automatically upon his suspension. Therefore, he contends he could not have violated 1.4a1 by failing to notify Mustin of that suspension because her informed consent was not necessary to terminate the representation. Sarver's suspension was effective the moment our order was filed with the clerk. That order required him to immediately cease and desist from the practice of law in any form, divested him of all of the rights, privileges, and prerogatives customarily afforded to a member in good standing of the legal profession, and effectively disqualified him from acting as an attorney in any respect. It did not automatically terminate his relationship with Mustin, however, as our order specifically required him to notify his clients. Had Sarver timely notified Mustin, the decision to proceed with new counsel or wait for reinstatement would have been Mustin's. Notwithstanding that order, Sarver failed to notify Mustin of his suspension and continued to represent her, signed her name to the settlement release and check, negotiated the check, which means deposited it, distributed a portion of the settlement proceeds without obtaining the required probate court approval. Those actions placed Mustin in jeopardy of violating her fiduciary duties to the estate and therefore required her informed consent. We therefore overrule Sarver's first objection. Sarver objects to the board's finding that he violated 3.4c, contending that the title, fairness to opposing party and counsel, the content of the rule, and the official comments accompanying the rule show that the scope of the rule is limited to a lawyer's conduct toward an opposing party. Because Sarver's failure to comply with this court's suspension order occurred after his first disciplinary action was complete, he contends his failure to comply with this court's suspension order cannot constitute a violation of 3.4c. This argument's without merit. The rule states that a lawyer shall not knowingly disobey an obligation under the rules of a tribunal. In addition, the preamble to the rule provides that the comments accompanying the rule explain and illustrate the meaning and purpose of the rule, but they are intended as guidelines. Moreover, we have held that the title and chapter of the rule does not limit the scope of the rule. On this authority, we conclude that the prohibition against a lawyer's knowing disobedience of an obligation under the rules of a court, contained in 3.4c, applies to a lawyer's conduct that occurs after the court has issued a final order. We therefore overrule Sarver's second objections. After independently reviewing the record and overruling Sarver's first two objections, we adopt the board's findings. The primary purpose of the disciplinary process is to protect the public from lawyers who are unworthy of the trust and confidence essential to the attorney-client relationship, and to allow us to ascertain the lawyer's fitness to practice law. In determining the appropriate sanction for attorney misconduct, a sanction designed to protect the public, we consider all relevant factors, including the ethical duties violated, the aggravating and mitigating factors listed in the rules, and the sanctions imposed in similar cases. We have recognized that the presumptive sanction for continuing to practice law while under suspension is disbarment. The parties stipulated that 4 aggravating factors are present: his prior discipline, his dishonest or selfish motive, his multiple violations of the rules, and the harm he caused to Juanita Mustin. The board adopted these factors and observed that Sarver had engaged in a pattern of lies that spanned both of his disciplinary cases, including lying at various times throughout his disciplinary proceeding about the advice he had received from the magistrate, though it did not expressly attribute aggravating effect to that determination. The board did, however, attribute aggravating effect to Sarver's lack of candor and his failure to acknowledge his wrongdoing in this case. The parties did not stipulate to any mitigating factors, and the board found none. In their post-hearing briefs, the parties suggested that the appropriate sanction for Sarver's misconduct is an indefinite suspension, and Relator proposed that conditions, including the payment of restitution to Jessica's estate or to Allstate, be placed on Sarver's reinstatement to the practice of law. The board considered 2 lines of precedent involving attorneys who continued to practice law and engaged in additional misconduct while under suspension, one line in which we imposed indefinite suspensions and one in which we permanently disbarred the attorneys, and it recommends that Sarver be permanently disbarred. This court is the ultimate arbiter of attorney discipline, and we do not need to adopt the board's sanctions recommendations, but we agree with the board that permanent disbarment is necessary in this case to adequately protect the public. The recency and severity of Sarver's disciplinary history cannot be overlooked. In November 2018, this court suspended Sarver from the practice of law for 2 years, with 18 months stayed on conditions for, quote, engaging in a sexual relationship with an indigent client in a criminal case, during which he also obstructed official business, committed trespass, and lied about the relationship to the judge. The facts were as follows. Sarver and JB met each other in 2012 when Sarver represented JB's then boyfriend in a legal matter. On September 11, 2015, JB reached out to Sarver when she needed a good attorney for felony. Some stupid stuff that happened, and I really need to talk to you. It's not good. The next day, Sarver and JB met at a Columbus restaurant, discussed JB's criminal case over drinks, and then had sex in Sarver's vehicle in the parking lot. Classy. JB was charged with theft in the Hocking County Municipal Court, and a warrant was issued for her arrest. Sarver subsequently instructed her to turn off the GPS on her mobile phone so that law enforcement could not track her. Several days later, a grand jury indicted JB for multiple felonies due to Sarver's advice to turn off the GPS on her phone. She avoided arrest for almost 1 month before being apprehended. The judge presiding over JB's arrangement appointed Sarver to represent her, and Sarver, now representing an indigent client as court-appointed counsel, engaged in more relationship activity with Sarver at least 7 more times over the next 4 months. They also trespassed onto Sarver's neighbor's property to use a hot tub. Although rumors of his relationship with JB soon spread, Sarver falsely denied the rumors to the judge presiding over JB's criminal case on 2 separate occasions. Detectives interviewed JB, and during her interview, she stated that Sarver had insinuated that he would help her with her warrants and cases for favors. She told the detectives that she had problems saying no to something like that. You feel kind of forced into it. And of course, I had something over my head. I was facing 7 felonies. Sarver pleaded guilty to 3 misdemeanor counts of criminal trespassing based on Sarver's unauthorized use of his neighbor's hot tub, and 1 misdemeanor count of obstructing official business with the advice to turn off the GPS on JB's phone. The board found Sarver's conduct violated Professional Rule 1.8J, prohibiting a lawyer from soliciting or engaging in that kind of relationship activity with a client unless a consensual relationship existed prior to the client-lawyer relationship. In other words, a lawyer can have a relationship with a client as long as the lawyer-client relationship came after the personal relationship and it was more or less ongoing. If the lawyer-client relationship precedes the personal relationship, that's a big no-no because the lawyer has some kind of power over the client, and that can quickly lead to a huge conflict of interest and coercive behavior on the part of the lawyer, and that can be leveraged against the client. It's kind of like a Weinstein situation. They also violated 8.4b, prohibiting a lawyer from committing an illegal act, 8.4c, prohibiting a lawyer from engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation, and 8.4d, prohibiting a lawyer from engaging in conduct that is prejudicial to the administration of justice. In reviewing the board's findings, the court emphasized the severity of Sarver's misconduct, acknowledged that the most disturbing cases are those in which the lawyer has had sex with a client while defending the client against criminal charges or has accepted it in lieu of fees. I mean, that's basically some kind of solicitation there, right? As the court had noted, the abuse of the attorney-client relationship not only harms the dignity of the client whose body and trust in her lawyer have been violated, Gesundheit, but it also impugns the legal system as a whole. Thus, for his violations, the court suspended him from the practice of law for 2 years, with 18 months conditionally stayed. Sarver had engaged in a pattern of misconduct and committed some of the most egregious and disturbing violations of attorney's misconduct, short of a violent felony offense, violating and abusing the attorney-client relationship and deceiving members of the judiciary. This court issued a sanction that would protect the public but would give Sarver the opportunity to be reinstated to the practice of law with the shortest suspension that could be imposed under the circumstances. However, despite this sanction, Sarver immediately proceeded to violate the rules of professional conduct by lying to this court and his client. Despite this court's efforts to prevent Sarver from committing future transgressions, Sarver continued his pattern. Within the first few days of his original suspension and continuing through the remainder of 2018 and well into 2019, Sarver violated 7 professional conduct rules in relation to his representation of Juanita Mustin and Jessica's estate. These violations spanned across 4 chapters of the rules of professional conduct and occurred at various times throughout Sarver's interactions with Mustin. This was not a single transgression or instance. This was a pattern of deceit and misrepresentation involving a grieving and vulnerable mother. After being suspended on November 28, 2018, Sarver did not inform any of the relevant parties of his suspension. Sarver lied by omission in continuing to represent Mustin and the estate. He then expressly lied to this court by filing an affidavit of his compliance with our suspension order, fully knowing that he had not notified any relevant party of his suspension. And then, building on his lies, he forged his client's name to the $50,000 check issued by Allstate and began using what he believed to be his earned fees to pay personal financial obligations. Sarver then disbursed funds to individuals with absolutely no entitlement to those funds to reduce the amount the estate got so as to avoid certain proceedings in probate court. Sarver did this without the probate court's authority to expend any of the settlement funds and while under suspension from this court. Making matters worse, Sarver attempted to justify his actions to Relator by falsely accusing a magistrate judge, another lawyer and member of the judiciary, of advising him to reduce the amount of the estate at the direction of the fiduciary to avoid certain probate proceedings. Sarver then made a feeble attempt to remedy the situation 7 days before his own disciplinary hearing by offering to make partial restitution in the amount of $43,266, the full amount of the settlement, less the funds he had dispersed to Mustin and Jessica's boyfriend. Sarver's actions are indicative of a selfish attorney who decided to wait out his suspension so that he could secure and use settlement funds during his suspension and then resume his representation after his suspension was over, clearly thinking no one would be the wiser. His misconduct, which includes practicing law while under suspension, warrants permanent disbarment. So then they go into the case law around disbarment, and basically they're going to say that he maybe could have been indefinitely suspended, possibly reinstated after some time, and then displaying that he could be rehabilitated, that he had been rehabilitated, and that he could practice law again. And the disciplinary committee is going to decide that he instead warrants permanent disbarment. We have consistently recognized that the primary purpose of disciplinary sanctions is not to punish the offender, but to protect the public. The aggravating circumstances and case law support a sanction of permanent disbarment in this case. That sanction is necessary to protect the public because Sarver does not possess the requisite character and fitness to competently practice law in Ohio. Integrity is a necessary characteristic for an attorney practicing law in Ohio, and Sarver does not possess this qualification. Sarver lied to his client in the case. He then lied to this court by filing a false sworn affidavit. He then lied to Relador. This is a pattern of misconduct continued from Sarver 1, in which he lied to a trial court multiple times and likely to numerous other individuals. We can only assume that Sarver's pants are charred from the number of falsehoods that he has perpetrated through Sarver 1 and this case. We must protect the public from lawyers like Sarver, who manipulate their clients, individuals to whom the lawyer owes a fiduciary relationship as well as ethical duties. In the oath for admission to the Ohio bar, attorneys swear or affirm that they will abide by the Ohio rules of professional conduct, will conduct themselves with dignity and civility, and will show respect towards judges, court staff, clients, fellow professionals, and all other persons. Sarver has disregarded this oath to the bar and his duties to his clients. Here, Sarver manipulated a grieving mother while representing her in the resolution of her daughter's estate. He forged his client's signature. He distributed some of the funds to himself and others, all without proper authority to do so and while under suspension. And in Sarver 1, he essentially exchanged his legal services for sexual favors from his indigent client in a criminal case. Like in the case at bar, he manipulated a vulnerable client in that case too. Sarver has a pattern of breaching his client's trust to pursue his own objectives, financially or otherwise, rather than act in the interests of his clients. Any sanction less severe than permanent disbarment in this case would be inadequate to protect the public. Sarver committed the misconduct in this case immediately following our disciplinary decision and during his suspension in Sarver 1. Permanent disbarment, coupled with the requirement that Sarver make full restitution of $50,000 to Allstate or the estate of Jessica Mustin, the proper restitution pay will depend on whether the insurer has issued a second settlement check to the estate, are necessary to protect the public from future harm. Accordingly, Jason Allan Sarver is permanently disbarred from the practice of law and ordered to make restitution of $50,000 to Allstate Insurance Company or the estate of Jessica Mustin. Costs are taxed to Sarver. Holy mackerel. That is an amazing amount of disregard for the integrity of the legal profession and the rules that maintain that integrity. And I am dumbfounded as to how anybody could practice law in such a way. That even goes beyond Leibowitz levels of misconduct and stupidity. I am just floored that someone would spend the time and effort to join such an honorable profession and then disregard every ounce of integrity and honor required to maintain your office as an officer of the court. Absolutely unforgivable. And I am happy that the Ohio Disciplinary Council Board, whose name I've forgotten, has taken it upon themselves to write such a well-reasoned opinion, hopefully not just deterring and preventing Sarver from ever conducting himself as an attorney again, but also maybe deterring anyone who had any future question about the levels of integrity and honesty required to be an attorney and represent clients in a fiduciary capacity, hopefully deterring them from ever behaving like that again. This is someone who learned how to be a lawyer from TV. I mean that as a metaphor, not as a fact. But this is someone who seems to have learned how to be an attorney from a TV drama about how horrible lawyers are, not from the actual rules and conduct of real lawyers in real life. and I hope that this has helped educate you as well. An attorney is not supposed to be acting like some terrible TV attorney like Saul Goodman or some others. We're watching Community, so Jeffrey Winger comes to mind, but he actually wasn't that bad. I mean, it's misconduct not to have a proper education, which is the story of Jeffrey Winger in Community. He didn't have a bachelor's degree, so he shouldn't have had a law degree. But he otherwise apparently conducted himself properly. Maybe he was a sleazebag, but there was no other accusation that he had conducted himself in a way that violated the rules of professional conduct. Certainly the underlying thing is bad enough, and maintaining that is bad enough, and he was suspended only to be reinstated after correcting and curing the problem. But this guy was also able to be reinstated after correcting and curing the problem and maintaining himself for just 6 months of a 24-month suspension, and he wasn't able to do that. So this is an amazing amount of misconduct. I'm really glad we went over this because I hope it teaches you, the public, that these disciplinary committees really do take attorney integrity seriously, and you can trust your attorney in most cases. But then I have to remember that even I have been the victim of attorney misconduct, and you can go back and watch my video about how my attorney got suspended, and not because of my case, but I feel like the same misconduct that got him suspended was also visited upon me in my case. Basically a failure to prosecute my case. And I was very injured from that in the sense of monetary damages. I had left a decent job because of a legal dispute, and then my attorney never prosecuted that legal dispute, and I was then never able to successfully even have my claim adjudicated at all, let alone be successful on my claim for damages. So that means that I lost some economic growth period of my life where I could have had 5 to 6 figures of damages and you know, had that to make a new life off of instead. Instead, I had to start my legal career as a lawyer with less than zero and actually in great debt to which I still haven't been able to pay off via student loans to this day. So yeah, it's really important that we take attorneys' integrity and ethics and rules of professional conduct seriously. The fiduciary duty means that the attorney acts in the client's best interests, not the attorney's best interests. So let me know what you think of that story in the comments below, and I'll see you for the next one. Thanks for watching. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program here on YouTube, on Floatplane, and on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern. This is a community-supported channel, meaning your monthly financial support makes these videos possible. Find out how to support the channel on patreon.com/ljfrench, sponsors.com/law, or you can become a member on YouTube or on Floatplane. Thank you to the $50 plus supporters for the month of December. These are Joe Tyson, Wes Delj, Mitchell Rowton, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Andy, Benjamin Hitov, Goliath Cleric, Ugly Grill, Shielo T, Rudolph Bescherer Jr., HotGrillsInYourArea, Oscar the Phrophet, Brandyn Abel, Torpedan, Cassandra Curran, Mayor of Titty City, ShadowTycho, RDHDragon, Earthbound Star, No Copyright Violation Intended, and Nathan McCarty. And thank you to the $5 plus supporters scrolling on the screen. Your support has made all of this possible. I love you all. I hope you have a great week. Stay safe, stay healthy, and I'll see you in the videos. Bye.